In this paper, I have tried to show the double bind one is submitted to when trying to grasp the notions of family from a philosophical point of view. Cécile, if you want, you can scroll to the,
Yeah.
yes, it's the,
do we have a problem?
it's
Sorry.
okay. I hear
Yeah.
some.
No, it's all good.
Okay.
Yeah.
On the one hand, I hold that philosophy of family, which only means to me the effort to bring back family into moral and political philosophy, needs to rely on the law, and not only on private and family law, but almost on all the law, all the fields of law. On the other hand, structural difficulties oppose such an undertaking. I have tried to present some of them, and the list of difficulties I gathered here is not exhaustive, but purely empirical. All these difficulties concern notional efforts, the efforts to portray, or at least to sketch, what family the law does speak of. Following difficulties have seemed to me interesting to mention. First, the diversity of competing definitional elements that are found in the law about family. For instance, alliance-focused notions versus filiation-focused notions of family. Second, the heterogeneity of legal registers that grasp the family. For instance, the fact to treat adults as children or children as adults, to treat spouses almost as properties, or in contrary, spouses as absolutely non-alienable beings. Third example, the plurality of competing family models that the same legal system promotes simultaneously in its different branches. For instance, the presumed innocent family of the civil French code and the sometimes presumed guilty family in certain social rights provisions or practices. This draws a very complex object to consider, and the family the law does speak of is nothing but simple, and maybe it's not even a consistent notion. Once this difficulty is listed, I return more explicitly to philosophy. This will be my fifth point. With so many forms of multiplicity and diversity, the philosophical task of unifying definitions and articulating diversity in notions is at stake. That is why, once again, from a very broad point of view and without any claim to be exhaustive, I list some main philosophical options that can help to cope with this plurality, with this huge plurality. So here comes a problem of division of labor between jurists and philosophers. I do not know enough about the way jurists cope with such diversity, as well practitioners as theoreticians, even if I read a little about it. I also know one should not search in the law what is not supposed to be there. But anyway, one needs a minimal comprehension of such an important notion of family. I just present the way philosophers could help dealing with this complexity. My point is that one cannot be satisfied with purely formal method to unify this juridical and legal object of family. One needs also to convene sociological and historical knowledges, as well as a political point of view. Why? Because if you do not do this explicitly, you're at risk to do this implicitly. My point is thus to advocate the necessity of social philosophy when it turns to family, and the necessity to include this philosophical option in the philosophy of law. These are mere proposals, and more, these are mere questions. I'm sure I will learn from your remarks, especially because French and English legal contexts are so different. I think we can talk about that particularly. So first, the law is necessary to the philosophy of family. In order to understand the nature of family, a perennial social institution, a human phenomenon that appears to be universal, and universal despite its strong variation, it's necessary to set aside conceptions that reduce it to the product of personal relationships and that ignore the role of law in its constitution. So there are two authors here mentioned. The family is not only an affective network who would be made of love and jealousy, rivalry and fear, or of influence. It's not either only made of pure relational spontaneity, which would be reinvented at every moment. It's not only a web of conversations and daily tractations, as would the French sociologist François de Singly, or the English one who inspired him, Anthony Giddens, I don't know how you pronounce it, how this sociologist asserted. And this sociologist view of the family has spread to philosophy. Many contemporary moral philosophers tend also to develop and advocate a rather desinstitutionalized vision of family, even if they think, as Rawls does, for instance, that family is a fundamental institution of society. They tend to overestimate the role of affection and the pre-legal status of this first sphere of socialization. Maybe they are influenced in this by Piaget, Kohlberg, and Mead, the social psychologist. For instance, another example, Axel Honneth only mentions the action of law in family when family breaks up. When the couple divorces. Law becomes a dangerous medium for him, an individualistic lens through which formerly united people consider their past relations, their past common life. And because of its way of keeping everyone apart from another, the way of the law, because of its way of distinguishing everyone's interest from another's one, law cannot be but destructive of whatever could remain in the family. So here in such a philosophy, constructive and positive functions of law, as well as restorative ones, are left aside. In contrary, family has to be considered as a product of legally recognized wills and more as a social and legal institution, that is to say, a condition at once legal, political, and social that affects individuals and constrains their action. For instance, some children, or even some children-in-law, discover in their life, sometimes in their old age, that they have to fulfill maintenance obligations towards their parents, or even towards their parents-in-law. And they have no choice to refuse, at least in France. I don't know the other system in Europe. Now, it's important to remember that not only civil law, not only criminal law and human rights, but all areas of law are crucial sources of information about the family. One should also mention the law of social aid and social action. I don't know the English term, economic law, political and constitutional law. Maybe a provisional definition of the family would be here useful. The family, I propose, is the institution that organizes life in society in small groups, groups whose perimeter results from the distribution of alliance and filiation. Most of the time, this familial association is organized around a home, around a daily domestic life based on intimacy, based on personal, sexual, conjugal, and sometimes intergenerational ties. These interactions the family is made of are rich, they're culturally determined, they cannot be anticipated as it would be the case in a mere contractual tie. So it's more a community than an association, if you want to use Tony's words. Moreover, the list of family functions also varies. But this list of functions contains mainly procreation and renewal of generations, but it's not necessary, I insist. socialization of the children, education, material organization of subsistence, material solidarity. As a sixth social institution, family thus associates opposite things, which it articulates together. It's defined by a structure of transcendent kinship, which distributes identity, like proper names, and particularly relational identities, kinship relations, to each individual. This structure is a condition of regular links of variable prosaic activities, which are called nowadays conjugality or parentality. I don't know, in French, parentalité especially is a new word, a neologism. And this is used to oppose their immanent character to the transcendent structure of kinship. So you oppose parenté and parentalité. These activities are made of care and proximity, of moral, affective, and material support. So we turn to second point, conceptual tensions in the law. Even though difficulties to extract the notion of family out of the law remain huge, jurisprudence cannot develop without at least a partial process of unification of this notion, and without the search of convergent practices, without some shared notions of or meanings. If judges, lawyers, or legislators refrain from making explicit their notion of the family in order to avoid to take theoretical risks, and if they nevertheless keep an implicit idea of the family, an idea that would act underground and surreptitiously, the risk incurred by these implicit meanings is heavy for individuals. Neither may philosophers give up to search for a clearer notion, even if there are difficulties. So, for instance, an example of this risk. I want to give an example of these risks. Some parents in France strive to acquire filiation for their child who has been procreated abroad using unauthorized medically assisted procreation, unauthorized by France. They thus put the French judge before the fait accompli by bringing the child to France. However, judges' responses vary widely, with some judges forcing proceedings to obtain filiation by adoption and some others strictly applying the law. This uncertainty subjects family to the lottery of the judge's personal convictions, and it deprives them of decisive legal security. It pleads for an explanation of the notion of family that are at work in practice. So, when it is understood and admitted that some definition of the family must be sought in the law, problems reappear anyway. In fact, it's impossible to find uniformity and simplicity in the family mentioned in the law. Instead of this, definitions of family are reconstructed, must be reconstructed by indirect means, and one must form them inductively. The family, it has been pointed out by Éric Millard, is not defined by French law, although it's often mentioned in the French law, and particularly in the Civil Code. You can only consider it indirectly in the Civil Code. And maybe Éric Millard explains, it's because the liberal legislator didn't want to confer on the family a juridical personality as a group, even if he cannot totally eliminate the mention of family. Liberal, and I wanted to say individualist. There is more. We discover in these definitions of the family, reconstituted from the knowledge of law, a great diversity of conceptions, very strong variations, even within the same system and even in synchrony, in the same system in synchrony. Sometimes, another example, there are a lot of examples I could give, sometimes based on the couple, the family sacrifices the well-being of the children in cases of separation, where the partners have sovereign freedom of decision of the future of their couple, to break or not to break. And the family transforms the children into a bargaining chip for their disagreement. But you can take the same couple several months later, and now the family is based on the bond to the children. And this family transforms some separated parents into authentic nomads who constantly crisscross regions, even countries, to join their own children every 2 weeks, for instance. Maybe you know some of these people. So some divorce arrangements, at least in France, in other lands, impose a kind of anachronistic moral punishment on this or on that parent, and if this, and sorry, as if his or her departure from the marital home was sanctioned, or as if they had to pay for their wish for professional development. Legal sociologists and feminist authors thus reconstruct the ideology underlying divorce decisions and arrangements that sometimes privilege mothers, sometimes privilege equality between spouses, and sometimes the child itself. So there are a lot of other examples. I gave the paternity example. Third point, the confusion of legal registers applied to the family. The tensions in the definitions of family do not only originate in the coexistence of two incompatible characters, but sometimes they also arise from the invasion of one legal area, one legal, one area of legal logic by another, as when laws adapted to one type of objects apply to another type of objects by superimposition or contamination, which in law are possible. And we would err if we thought that this only happens in medieval law. So I gave a large example of this case arriving in medieval law about the right to the spouse's body. But I gave this example to show that it's the same today. Such confusions threaten indeed often our moral categories today. For example, if we look at welfare law, historical practice shows a growing confusion between treating parents as adults individuals and as minors under the guardianship of the state. It also shows another confusion between penal response and therapeutic response to child delinquency. Maybe the two registers are confused. The reduction of human beings to the status of property itself is not absent from contemporary law, and that is what the French jurist Muriel Fabre-Magnan denounces in Instituer la Liberté. I quote, US law sometimes extends the property model even to filiation. For example, in matters of surrogate motherhood, some argue that just as a song or invention is protected as a property of the author of the concept, in the same way, a child should be regarded as belonging to the originator of the concept of the child. So this is another source of difficulty. I turn to the last type of difficulties I propose, but there are certainly a lot of other I didn't mention. These above-mentioned sources of confusion are accentuated by the diversity and mutual links between the fields of criminal, civil, welfare, and political law. These fields do not always complement each other harmoniously when it comes to the family. It's true that civil law sometimes merely sketches familial obligations, and then that criminal law sometimes explains it in concrete terms. But it's also true, and it also often happens, that non-criminal family law and criminal family law radically oppose to each other, not to mention human rights family and welfare policy families. And a tension I wanted particularly to present was this following tension. The spiritual, voluntary, and moral definition of the family, which is given in the French Civil Code, which was originally given in the French Civil Code, is today stretched and sometimes torn apart in two incompatible directions as far as they come from interpretations which are foreign to civil law. On the one hand, there are very strong normative requirements of welfare law. These tend to remove the parents of, quote, les guillemets, je sais plus comment dire, to remove the parents of dysfunctional families from their position as legal subjects, and they tend to substitute a therapeutic or managerial attitude, often sociologically deterministic, for the legal response. On the other hand, there are tendencies toward abstraction, spiritualization, or decorporalization of the family that come from the extension of the philosophy of human rights. For instance, according to this jurist, Muriel Fabre-Magnan, human rights are not in question per se, but rather the reading that is made of them at the European Court of Human Rights, which tendentially moves from the negative freedom that human rights originally conveyed to a positive conception of freedom. So it comes from freedom from to freedom to. And when you compare these two families, you see that the contrast between families of social workers and families of the European Court of Human Rights is striking, even if it's the same family. For instance, in the 70s, the French sociologist Claude Lycia, in Famille hors la loi, this author underlines that social workers comment in their report on the family they visit. They give comment on the physical appearance of the person. You find such unacceptable mention as gypsy type, hairiness, and so on in their reports. They monitor and evaluate their parental competencies according to implicit norms that are often pejorative and condescending. It's obvious that only these poor and disadvantaged families suffer such an intrusion into their intimacy. At the European Court of Human Rights, in contrary, the judge sometimes responds to family requests, not taking into account, sometimes at all, sometimes partially, the bodily condition, health of the complaining families. As a result, European court decisions can become a rival family policy to national family policies, so it gives another tension in the definition of family. So this court's positions become a policy that does not say its name, and certainly not a proper right, because the essence of right lays precisely, according to Kojève, if we take his definition, in being distinct from a policy. So, Cécile, you may scroll a little. Therefore, thank you. Therefore, one should not oppose human rights as they are today and civil law. One should rather make the distinction a little higher. Thank you. One should rather make the distinction within each of them between what is political and what is pure right, what Kojève calls the pure anthropological phenomenon of right, which always involves an impartial third between two parties. And here is a problem that the state can intervene under two qualifications, which are very different. The state is often this third party. He often represents this third party. But the state also intervenes in other ways in social relations. When the state promotes a family policy and when the state implements it through the tool of law, it no longer acts as a neutral and impartial third, but as an agent defending this or that program. In this case, the law exercises a function that is not repressive, separating, and restorative. It's not the pure right, Kojev points out, but it's a promotional function. So I gave here several points that make clear the fact that it's very difficult to get a unified notion of family in the law. But although it seems a heavy task, there are several methods to reduce these tensions and contradictions. So I turn to the fifth point. Some methods operate a priori, and they are purely normative and formal. They are not concerned with the content of the norms, but only with their hierarchy. The Kelsenian normativist treatment of contradictions in law, for example, does not want to highlight implicit contradiction, and if ever explicit contradictions arise between two norms, this method applies an a priori defined method. So this Kelsenian applies an a priori defined method. He looks for a norm which is superior to the two conflicting norms, letting the treatment of the origin of this contradiction to other actors and averting jurists from these slippery considerations. Do not approach this problem. Such a method has the sole advantage of settling conflicts of norms, but not conflicts between two conceptions of the family. And this gain benefits only to the consistency of the legal system, not to its institutions themselves. One could also mention the just naturalistic way of getting rid of these contradictions, which is though too much unhistorical. Families now share with other institutions the realization of certain functions. For instance, 5 minutes. Okay, economy, education, procreation, and generational solidarity. But when education is shared between school and family, subsistence between the economic sphere and family, and when generational solidarity is shared between family and social insurance systems for old age, it's absurd to resort to the philosophy of natural law. What is needed here are philosophical methods that do not rely solely on the internal coherence of law, which means methods that find outside the law the basis for its unification. Family philosophy must certainly borrow its method from social philosophy. That is my point, for it is insufficient to unify such an object from law alone. It's not a question of leaving philosophy for another discipline, who would be history, sociology, economics, or psychology, but it's a question of complementing the normative legal philosophy of family with a social philosophy of the family. Okay, so I turn a little. So I proposed three possible solution who enter more in sociological knowledges. I pass on political voluntarism, and I go to sociological understanding of the politic and law, and I gave two examples of Tocqueville and Durkheim. On the subject of family equality, Tocqueville proceeds in a sociological manner. Equality is first of all a fact which must be dealt with. It began in families, which equality of inheritance, and then from this nucleus of successoral egalitarian laws, other egalitarian phenomena have appeared, confirming this irresistible egalitarian movement that comes more from private law than from constitutional law, but which produces unification and consistency in the law. So when he faced some contradictions, for instance, a family who wants not to be equal to the others, he considers it as unhistorical, as anachronistic. And when he finds some example of person who don't have any kinship as slaves, he presents it as a pathological situation. I turn to the third and last method. I don't know if I have a little time again. This is a political understanding of the sociological, and this is the Habermas proposition. Between a purely constructive policy that indicates the desirable directions but does not verify their possibility, and the acceptance of the ongoing historical and social movement, Habermas has refused to choose. He has proposed another method who is not only constructive and not only factual. He proposes to simultaneously reinforce normative reflection and social knowledge and to nourish one by the other. This is his point in Law and Democracy. So the advantage of Habermas' method is that he wouldn't advocate for a family model who would be sought outside of society, as does, for instance, Daniel Bourriaud in La Famille par contrat. He neither resolves to always follow the sociological movement without trying to influence it or to judge it. So he states that constructive politics are meaningless, is meaningless when it's purely abstract, but he doesn't follow the Durkheimian sociological perspective because he wants to see the sense of diverse institutions and the sense of diverse institutions together. So what could I say to be a little, to get a little quicker? I took the example of education and how it would be treated by Habermas. About this question about education and family, we have to ask, how is the contemporary division of labor between school and family arranged, and how should it persist? If we don't ask the sense of these both institutions, we couldn't do anything with them. Parents can feel both dispossessed by teachers and ask, for instance, why should teachers give sex education to our children? And they can feel also abandoned by them. Why don't they do more for children, etc., etc. Parents do not really know if they have right to interfere in the school, if they have right to remove their children from the school, or if they themselves have pedagogical duties, and which. Pure law does not give the answer to such questions. Although these questions engage law, it would be ridiculous to answer to this pedagogical and sociological issue by only invoking parents' rights, but it would be also impossible to consider this question in a pure political way without dealing with legal and even coercive means one has to use to enforce education. It would be more fruitful, and that's a Habermasian way of doing, I think, to consider this division of labor globally, to try to give a meaning to it, and to reflect both parents and teachers on a co-education. So I turn to the conclusion, sorry for the delay. Among the three philosophical solutions proposed here to tame and understand this diversity offered in law, first, political voluntarism, second, consideration of the whole of society, and third, Habermas' more Kantian and evaluative solution, the third seems the most adaptable to the evolution of law and the most appropriate to this omnipresent institution of family. One of the main stakes of this work is to help us consider the importance of families' activities, functions, and work, and perhaps to put identity questions just a little aside. However important this latter may be, one should not focus on the sole issue of who has the right to be a parent, to marry, to be a child, etc. One should also try to remember that what we do in the family and what the family does to us. And this is a philosophy of law question. This could seem a modest proposal for philosophy, but this modesty has become today necessary. Thank you.